Mamuina Akwaba at the Bankasa TV. Andra da ewo mrashibdi fi dom kuma press conference and no dimpa mu se do meti ase ama Kpandai city me declare the vacant enti no omuina shatade tuntum press conference din ne asem ketu a chese Supreme Court clerk kata no de abana ya do media tumu ne agia tumu tinani enti no mo twen notice from appeals court and afisun Accra High Court about the Kpandai constituency. The clerk of Supreme Court at their panel trono and ya do metias in atia search na native yes reputi bofu potokasa the minority in parliament said to da endrada ewo mrashibudi fi midamuinas
on the constitutional rights of the people of Kpandai, a dangerous breach of the separation of powers and a redress and a reckless disregard for both our judicial process and our own parliamentary history. This House is on the verge of committing a constitutional travesty and a historical self-betrayal. We have taken note of a formal communication from the Clerk of Parliament, issued pursuant to the contested High Court order notifying the Electoral Commission of a vacancy in this Honourable House. On the strength of that notification alone, the Electoral Commission is expected to regard the Kpandai parliamentary seat as vacant, though it is a seat that was decisively won by the New Patriotic Party with a clear and commanding mandate of a difference of 3,734 votes. But here is the profound constitutional and historical defect at the heart of this matter. As I stand before you, the Honourable Member for Kpandai, Matthew Nyindam, has duly exercised his constitutional rights. He has filed a stay of execution, halting by the operation of law the effect of that very judgment. 2. He has lodged a notice of appeal to the Court of Appeal. And 3, he has initiated an application for certiorari at the Supreme Court. I ask, what manner of parliament are we in that we would rush to enforce a judgment that is legally suspended, ignore appeals that are actively proceeding, and arrogantly presume to be preempt our superior courts before they have uttered a single word? Worse, why are we abandoning the wise and restrained precedents set by this very House? Let us consult our own ledger. Our institutional history reveals a consistent bipartisan practice of protecting a member's mandate until the legal process is conclusively settled. We have never treated a contested first instance order as an immediate death warrant for parliamentary tenure. Let me cite specific examples. In the case of Samuel Nyemekan of Welensee, after the High Court voided his election, he filed an appeal. What did this House do? It continued to recognize him as a sitting MP throughout the entire appeal process. The seat was only declared vacant after the Court of Appeal delivered its final judgment. In the case of Eric Amwatin of Nkranza South, detained abroad on serious charges, this House resisted calls to declare his seat vacant while his legal status was unresolved. Vacancy occurred only upon his own properly executed resignation. In the case of Danawodapi of Keta, convicted and sentenced to 10 years imprisonment, this House did not treat the conviction as an automatic trigger. when circumstances allowed. When he was granted a presidential pardon, he returned to this chamber on 10th of June 2008 and was permitted to sit and perform duties as MP. His tenure ended with the dissolution of Parliament. In the case of Adamu Dramani Kpandai of Boko Central, the honorable member continued to serve in Parliament for years while the courts determined civil challenges to his eligibility. It was upon his final criminal conviction and subsequent imprisonment in July 2012 that he became legally incapacitated from performing his duty as a member of Parliament. Even as he pursued an appeal, he was granted a presidential pardon in December 2012. In any case, a by-election could not have been constitutionally justified since his incarceration occurred less than 6 months before the 2012 general election. Let me address the case of James Jechi Kwesi, which is often mentioned. A clear look at what actually happened shows why rushing on Kpandai is wrong. Here are the facts. Kwesi was sworn in and served as MP in January 2021. Even though a court case was already pending, Parliament allowed him to work, just as we have done in other cases. In July 2021, a High Court nullified his election, but even then, Parliament did not immediately declare his seat vacant. The real change came from the Supreme Court. In April 2022, the Supreme Court issued a direct order, an injunction commanding Kwesi to stop acting as an MP. And in May 2023, the Supreme Court gave its final judgment, ordering Parliament to remove his name. The lesson is clear. Parliament decisive action in the Kwesi case was not based on High Court ruling alone. It was based on specific final orders from the Supreme Court. Now compare this to Kpandai. Today, we have no order from the Supreme Court. We have no injunction. Instead, we have a High Court ruling that has been formally stayed and is under appeal.
Of Youth Employment
to use the Kwesi case to justify instant action in Kpandai turns the truth upside down. Kwesi's case teaches us to wait for the Supreme Court's final word. In Kpandai, we are ignoring that lesson.
Ghana for chassis for drivers now.
We cannot use a case that requires court intervention to justify acting when the Supreme Court has not spoken at all. The pattern, therefore, Mr. Speaker, is undeniable. This House has always required one of three conditions: the exhaustion of appeals, a final specific order from the Apex Court, the member's own resignation. Article 99 1E of our Constitution is precise. A seat becomes vacant upon a determination by the appropriate judicial authority.